You're listening to the Tilted Lawyer Podcast, a show that inspires the legally challenged to enter the courtroom armed with a plan. I'm Omar Serrato, owner of the Eagle Law Firm, experienced litigator, and the man you want to talk to before your big case. My co-host is Iliana Clone Rosa, owner of Clone Rosa Law, and a rising star in Southern California. Hello, everybody, and thank you for joining the Tilted Lawyer Podcast. It's a pleasure to be with you. It's been a little while since we have had a show. It's been a couple of weeks. We were out last week because I had a busy court schedule, and Iliana was stuck in Puerto Rico, being held hostage by the weather without internet or telephone.
Yeah.
Well, she had telephone. I actually talked to her over the phone a couple of times, asking if she was coming home. She's like, "No, I'm stuck in a hurricane." It's like, well. But she's home now and she is safe. But before we get into all of that, I'd also like to welcome the rest of the Eagle Law Firm staff. We're also joined by Melissa Pacheco and Jocelyn Escada. They're over here sitting on the couch, and they are here to observe and chime in when needed. We do have a tremendous show planned for today. We're going to talk a little bit about defamation and how it may or may not apply to your family law case. We're going to talk a little bit about courtroom presentation and what you might be able to learn from the Parkland sentencing trial that's going on right now. There's been a lot of fireworks in that case. And I don't know if you've been watching that, Iliana, but the judge in that case really strongly yelled at the defense attorneys for wasting everybody's time. And so we're going to talk a little bit about what happened there and how you could avoid pissing off the judge. When that's the one that's going to be making decisions in your case. We're going to also talk a little bit more in depth about 3044 presumptions, because I got a lot of questions about that. We actually posted a video on the 3044 presumption, but it was only like 3.5 minutes long, and it was informative, but people wanted us to go more in depth, and so we will. And if we have time, we're going to discuss Palimony, what that is, why it's not a thing in California, and in case you were wondering in what context it's even relevant in the state of California. But before we get into that, let's get started. So defamation, I get asked all the time. And honestly, when I first started the Eagle Law Firm, one of my first cases was a social media case. And it was somebody that was getting slandered, as they said, or defamed on social media. And it was on a fan, like one of these Hollywood fan club websites. And they have a whole separate community over there. But anyway, these people were engaged in this community. They were going to, I guess, like Oscar events or whatever. And they had gotten into arguments about each other and were saying, well, stuff that would offend, normal people. And one of my first cases was writing a demand letter asking the person that made those statements to take them down. It never got litigated, and it was a simple case, but apparently it was effective because I never heard from either one of them ever again, and that was the end of it. But Iliana, how many times do you get asked about whether or not you could sue the other party for defamation in your family law cases or any cases?
Oh my God. I would say like maybe 90% of the cases. And we're talking family law. It's just people constantly ask about suing the other person for the other person saying, I guess, lies or things that they don't want to be out there. But yeah, all the time. I would say all the time. And so far, I haven't really had a case where there's actually the requirements for a defamation case. It's rare in family law cases.
Well, in family law, the defamatory statements are not necessarily rare because they happen all the time. People make accusations and throw stuff out there.
Yeah.
But I think it's important that people have to understand what defamation is. And what it essentially is a published false statement about another that's heard by other people that causes injury to the person that the allegations were made against. And so in the context of defamation, In a family law case, oftentimes it's you guys are going back and forth to each other, but oftentimes the allegations are made in the context of litigation. And so if you get on the witness stand and you start making statements against the other person, whether it be allegations of domestic violence or allegations of substance abuse, allegations of infidelity, whatever it is, even if there's people in there in the courtroom, what most people don't understand is that those are privileged statements because they're made in the course of litigation, meaning that when you're writing in your pleadings, you're always doing that under penalty of perjury. So there's already that you're promising you're telling the truth to the best of your ability. But the second thing is that the statements that you make in court, even if they're false, are privileged so that you don't get to attach additional litigation to the pending litigation by saying, well, we just won our case, so obviously everything they were saying was true. That would just tie up the courts. And so for that reason, anything made in the context of litigation is privileged. So we should talk a little bit about that. A published statement, what does that mean? It could be a statement that you make, say, at a dinner party, at a Christmas party, at a whatever, at a lunch gathering, a spoken word to somebody. That's a slanderous statement. That's what slander means, a spoken statement heard by others. Or it could be written. Written is considered libel. But what you should understand is that slander and libel, they all fall under the umbrella of defamation. It's all the same thing.
Yes.
So all a published statement is something that somebody else could hear. Nowadays, that could be social media posts. It could be bad reviews on Yelp. It could be interviews that you give on TV or radio, which is historically where defamation law has come from. It could be any of those things. It has to be false, and it has to cause injury to the person that you're making the statement against. To give you an example of where that would be relevant, I was telling you yesterday a little bit about Hans Niemann, the chess player. And to give a little more context to what everybody else is talking about, I'm going to share with you this clip. And so at least we're all on the same page. This is a clip of what we're talking about. All right. So before I put everybody to sleep, this is what they're talking about is it's this young man. He's 19 years old. He's an up and coming chess player. He's really, really good. His chess rating prior to the cheating scandal was pretty close to 2,700. Chess rating is a way of determining how strong you are as a chess player. So an average chess player might be rated 8 to 900. A competent chess player might be rated 1,200. An expert might be rated 1,800. An international master, 2,400. A grandmaster, 2,600. And then the super grandmasters, meaning the best chess players in the world, are 2,700 plus. How many people are rated above 2,700 in chess? There's less than 40. And so usually when somebody cracks the 2,700 barrier, there's this progression that happens. This kid just kind of stormed the gates and just out of nowhere showed up to an over-the-board tournament against the greatest chess player of all time, Magnus Carlsen. If you want to check his resume, feel free to Google him. But he's considered by most, if not all, to be the greatest chess player who's ever lived. So he plays Magnus Carlsen over the board. He beats him over the board. And then he proceeds to give an analysis about how he did it. And after the game, Magnus Carlsen is speculated to think that Hans Niemann was cheating in that game. And the reason why is because he put out a tweet basically stating, I can't say anything because I don't want to get in trouble, which is to say, I don't want to say anything because I'm assuming he doesn't want to give a defamatory statement. And the reason why that's a big deal in chess is because chess people, chess fans, which I consider myself to be one of, are dorks. We follow this stuff very closely. And so when somebody's accused of cheating and they're in the super grandmaster realm, your reputation is scarred forever. It doesn't matter if you cheated yesterday or you cheated 20 years ago, 40 years ago. That stigma will always be with you. The reason why Magnus Carlsen is considered the greatest ever, he's never had any of those scandals. He's proven himself over the board over many years. He's been the world champion for the last 10, 11 years. And so he's vetted. But if you are found to be a cheater and you're new to the party, nobody's going to respect you. Your career might be done. Your earning capacity could be severely hurt because you're not getting invitations to these tournaments because you're a suspected cheater. So if Magnus Carlsen were to come out without proof and state that, yeah, the only reason I lost is because Hans Niemann is a cheater, he can be sued for millions of dollars for prospective lost income. That's where defamation comes into play. So if you're looking to file a lawsuit for defamation, it has to be a statement that occurs outside of litigation because litigated statements are privileged. Maybe it occurs in the workplace. Maybe it occurs on social media. Maybe it occurs. Was that
That's
you?
my house.
Oh, okay. Is that the drill? Or what did you call it?
There's
The Florio. What's the Florio?
in my house.
Taladro. Taladro? Is that a taladro?
Yeah, yes, it is. They're installing, I think, the cabinets today. Sorry.
That's okay.
I didn't expect this.
I'll ignore it. I'll ignore it. No worries. Anyway, so defamatory statements, that's what it is.
Yes. And I want to mention in the family law context, what I find a lot is that one of the three requirements is not there. Either the statement is not false, it's just hurtful, but it's not false. So if it is true, then it's not defamatory. A lot of times also it's not really published. It happens between the couple and nobody else hears it. And just because it was a conversation between the two of you, that doesn't, it's not published. And another one is the injury. Sometimes there's the publishing, sometimes it is false, but was there really an injury? Like just hurting your feelings a little bit and then that's it. It's not probably going to be enough for a lawsuit. Or if you want to go that way, it's going to be a lot of money. And for what? Exactly.
Could you think of a scenario where defamation in a family law case might hold?
I think usually when it has to do with domestic violence and like accusations about domestic violence, false ones, and maybe the person that is being accused is part of a religious community. I don't know, maybe he is or she is a director of a school, and that type of accusations might cause her or him to lose their job or their position in their church. I think that's usually where I have seen, like, maybe, of course, you could do a defamation case, but what about you? Have you seen any?
No, I was thinking the same thing. It would have to be a situation where you get one of these clients, they start calling family members and maybe his ex-partner's job and saying that, oh, well, she's a, whatever name, and she did all of this stuff and she started stealing from your company and you might want to take a look into that because I think that she's a thief because she's been stealing all of my stuff. The next thing you know, she's losing her job or he's losing his job because of those statements or being called into question. Those are published defamatory statements. Published doesn't mean it has to be a publication. It just means somebody else needs to hear it.
Yeah.
So, and what you were getting at before is it gets to that other element where if the communications are privileged, then defamation cannot hold. And one of the places where they're privileged is in the context of litigation, inside of a courtroom, where you're on a witness stand making statements. You're protected against defamation for the reasons that we had already stated. What do you girls have to say about defamation, if anything? Questions, comments, concerns? He's defamating. Do they actually say it like that? They're defamating me.
She's slandering.
Oh yeah. Do you ever get
Mhm.
demand letters like that, Iliana? Have your client stop talking stuff about my client?
I haven't gotten one in a while, but I have, yeah, before, definitely.
Yeah. Well, I guess the bottom line is, if you're thinking about bringing a defamation lawsuit, number one, you don't bring that claim in family court. That's a civil lawsuit. Number two, you really have to look at the elements. Is what they're saying false? And is it demonstrably false? Can you prove that it's false? If you can, all right, that's step one.
Mhm.
But then you got to prove the injury, because somebody might say something false about you, but nobody cares. And so you're not a celebrity. It's not in the context of your job. Somebody just told your best friend, and who cares about that? What's the injury? What's the harm? If there's no injury, then there's no case, and you're going to lose for failure to prove injury. And then, is the statement privileged? Are they making this in the context of their pleadings? Are they making it in the context of being on the witness stand, saying this stuff in front of the judge? Because if so, that's not a defamation case. That's just a family law case that's in the midst of litigation. And so just understand, if you want to bring a defamation case, it's a different thing. It's mostly about money, injury to reputation, and not in the way that you think. And for example, Amber Heard, the Amber Heard case, Johnny Depp case, that was a defamation case where she made all kinds of domestic violence allegations against him. And he proved his injuries to the tune of, I forget how many millions of dollars it was, but he was awarded millions of dollars for lost employment because he lost movie deals because of her statements, because he was blacklisted from Hollywood, and he was able to prove that at trial. And that's why he won that case. Amber Heard similarly also had a competing defamation claim, and she was also awarded damages, but Johnny Depp was awarded more. So in a nutshell, that is defamation. But moving on to courtroom presentation. Do I have my transition? I did, but it wasn't live. You know what else wasn't live? My intro, now that I think about it. That's the transition sound. That's what's supposed to happen. A couple weeks ago, I tried to have Jocelyn. When you weren't here, I tried to have her be the producer, but she forgot to press the buttons, and so we just didn't have any sound effects. No big deal. I could just add it in post production. So, courtroom presentation. One of the things that I want to focus on. We've talked a lot about how to present your case, how to present relevant facts. We've even talked a little bit about not pissing off the judge. But I'm going to play a clip, and I want you to tell me what you think about it. I don't know if you've seen this or not, so I'm going to play it for you. Could you see it there on screen?
No.
There it is. There it is. All right, here it goes.
Yes.
But I understand what you're saying.
To help me because
Okay, who's questioning this witness? Hello?
which witness?
Your next witness.
These don't have anything to do with it.
Yeah, we're just entering them.
These are just records. We're just doing it now.
So is it a secret who's gonna be questioning your next witness? Because I'm gonna find out in like 3 minutes. Who was doing it?
If the records don't relate, but if we call the witness, it will be me. I'm assuming you're talking about that.
Who is your next witness and when are they being called and which attorney is going to question them? Let me be clear if I wasn't before. Because if these don't have anything to do with your next witness, then why are we having the jury wait outside right now?
Just because we were trying to move everything in because in terms of timing, we do it now.
In terms of timing, it would be much better to do it during the lunch break when the jury needs longer than you all. So we'll go ahead and pass on this. Let's bring the jury in, please.
Your Honor?
Yes?
At this time, the defense rests.
Other than putting in our records.
We're not playing chess. I mean, will you please take the jury back in? Thank you. All right, go ahead and put in your records.
2B, Nicholas Cruz Henderson, episode 1 record.
Let me just stop. State, are you gonna have anything ready for today?
No.
The
We're
defense last told
expecting,
us there was 80 witnesses.
we're waiting for 40 more witnesses.
I just want to say, this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision until this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly have never experienced a level of unprofessionalism in my career. It's unbelievable.
So Judge, if we had any pretrial matters, you asked us to be here at 9:15. We were here at 9:15 to discuss pretrial matters. I have been practicing in this county for 22 years.
You know what, I don't want to hear it. I don't want to hear
Well,
it.
Judge, you're insulting me on the record in front of my client, and I believe that I should be able to
Okay,
defend
you
myself.
can do that later, you can make your record later, but you've been insulting me the entire trial. So, blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So, quite frankly, this has been long overdue. So please be seated, you can receive the evidence, I will receive the evidence, and then you can put whatever you want on the record at the end. Go ahead.
2B, which is Nicholas Cruz Henderson Records, Episode 1.
I'm sorry?
Episode 1, Henderson Records for Nicholas Cruz.
So that's pretty much the gist. That outburst from the judge, and I'll give some context to what's being seen right there. So that is a sentencing hearing. They're not trying to decide guilt or innocence. They're literally just trying to figure out whether or not he's going to receive the death penalty or not. And if it's not death penalty, it's a life without parole. And the defense team had submitted a witness list that was 80 witnesses long. And because they had submitted that list, the judge set aside multiple days for them to present their witnesses. And I think at that point, this has been going on for, I want to say like a month now, but they had put on 25 witnesses. They had another 55 to go. And you saw what just happened. They just, out of nowhere, Your Honor, we rest. And then the judge is like, what the F? What the F? And prosecution, are you going to have anything ready? Well, no, Your Honor. I thought they had 40 more witnesses. Of course, we don't. And why that's important is because when you're in trial and you got witnesses, witnesses are people and they got jobs, they have families, they have schedules. And so they have to make time to get down to the court. Sometimes they got to fly in. Sometimes they got to drive in. They got to take time off of work because they have to have some kind of reasonable expectation of when they're going to testify. So the defense team had instructed the judge that they needed all this time to present their 80 witnesses. And then, the judge was already getting frustrated. I hear the chloro over there. What's it called? Taladro. Taladro. Yes.
Taladro.
Taladro. The taladro.
Sorry. Yes, taladro.
The judge had set aside all of this time for them, and then they just decided to rest their case. So the judge, it appeared, was already getting frustrated with the defense team, and she had made reference to several other things, like, you guys are showing up on late when you don't like my rulings. You guys are giving me dirty looks. You guys are doing all of this stuff. And it's a team of defense attorneys over there. And so what, if anything, could you take away from that if you are trying to present in front of the judge? What would you tell people they could learn from that?
Definitely do not piss off the judge. Be considerable of the judge's time, the court's time, the other side's time. And I mean, from what I saw, it seems that they had already been doing stuff to piss her off. So this was just the last string. I think if maybe they had not done all that she mentioned, like being late on purpose, for example, or taking off the earphones, it would have been I don't know, maybe she would not have exploded like she did. I don't know. But also, I mean, I read about this. I had not seen the video. I was surprised like what they did. I mean, I know it's a decision, but I don't know. It like having all those people waiting there and just all of a sudden making that harsh decision. I don't know. I think I would be pissed too.
Well, have you ever pissed off the judge that way, where she's screaming at you like that, or seen a judge get pissed off in all your time in court?
I've seen a judge get pissed off all the time with
Mm-hmm.
attorneys, improper parties, all the time. Getting pissed off at me. I mean, I've had a couple of them, but their judges are always pissed off at everybody. So I
That
haven't
happens.
really taken it personally. But I mean, not one case that I can remember. Like, oh my god, like I did something wrong and they got pissed at me. It's been just cases where the judges are just pissed at everybody. Like, and it's like, okay, I'm just another one in line.
Yeah, no, I've never pissed off a judge that way, but I've definitely seen judges get frustrated. But usually when they're frustrated, it's because it's a complicated case. There's a lot of witnesses, and we've been in there all day, and let's just move this along.
Yeah.
Like sometimes, and you take your cues from you have to take your cues from the judge. Let you know their temperament, especially when it's not a jury trial, and they're the ones that are going to make the decisions. If they're indicating to you that what your witnesses are saying are no longer relevant, then you got to make that call.
Exactly.
And sometimes I've had it where, Your Honor, just so you're aware, I have 4 witnesses ready to go right now. But if you tell me that this specific thing is not an issue, then I don't need 4 of them. I only need 1.
Exactly.
And then we might have a sidebar, go in judge chambers, and we'll discuss, and then the judge will let you know what he is interested in hearing about, and we take it from there. But you can't play those kinds
They'll
of
let
things.
you know when they don't want to hear.
Yeah. I mean, you can, especially if you're going to be pro per. In pro per, I feel like judges try to be more patient, but I think when I see pro pers get themselves into trouble when they're trying to represent themselves, is they're not taking the cues from the judge, or they don't know how to take the cues from the judge because of lack of experience. I don't think it's going to get to the point where, I mean, obviously don't say you got 80 witnesses and only call 25 and then rest in the middle when we devoted days to this. So now we've just wasted everybody's time, and, don't do that. You're not going to have that much time anyway. But if the judge is telling you, if the judge is asking you a specific question, answer that question. Don't proceed to then tell the judge about like what an asshole the other side is, and, all the things and all the reasons why you don't like them or you're angry. Nobody cares. For one, I've talked about that many times. But I think when most pro pers fall apart is just not knowing what is relevant. But what I'll also say is there are good attorneys and there are bad attorneys. And family law is a very specialized litigatory skill. And there are some attorneys that should not be practicing family law. And they're the kinds of attorneys that try to treat it like it's a civil case, like we're, there's corporations are the parties, and we're just going to throw every single motion and, every kind of argument, when that's not really the objective of family law. We're trying to settle cases most of the time with children involved. And so we treat these cases differently. And if you litigate that way, or your attorney is litigating that way, chances are they might be pissing off the judge. Like if it's endless discovery and endless contempt motions and endless discovery motions and motions to compel and all of this, little stuff joinder here and there, sometimes it's relevant, but a lot of the times it's not. And if you have an attorney that is unnecessarily escalating issues, you may have an attorney that might be frustrating a judge. And granted, probably not, because I feel like in family law, these cases don't last that long where we're spending days on motions. And of course, sometimes they do. But you want to make sure that you have an attorney that knows that knows the judge, for one, and knows how to present in front of the judge, knows when to escalate, and knows when to not. Because there's a million different ways on how you could complicate a family law case and drag this on. And there's, there's a million ways where you don't have to, where you could avoid those kinds of things. And you might want to take another look at your case if if you're wondering why your case hasn't settled, sometimes it's not settling because you guys just need to go to trial. Sometimes that's how it is.
Yeah.
But I've seen cases within the last couple of weeks that, couples that have been in these proceedings for almost 5 years now. And then it's like, why has this taken this long? And then I look at the docket on their cases and there's 27 different motions that were filed. And, a lot of them are redundant. And it's like, what is all of this for? And how much money did you spend on all this stuff? And what was the end result? Like, what did you actually accomplish? So a lot of times you get those cases when you get some of these family law attorneys that treat it like it's a civil case. There's multiple reasons for that. And sometimes it's legitimate. Sometimes it's because they're trying to run up your bill. And that happens a lot. I mean, I'm not accusing anybody directly. I'm just speculating as to why that may be. Maybe they think that, hey, so they dropped her off 3 minutes late, and so you should file a contempt motion because they were not on time. And if they do it again, it's stuff that should really be handled by the parties, but the attorneys want to jump in and, further escalate. So courtroom presentation. The takeaway from this Parkland video that we just watched, if you tell the judge that you're going to present something, you better present it. And if you're going to decide not to present it, you let the judge know in advance why.
Yes.
So that the judge doesn't accuse you of playing chess in the courtroom and yell at you and waste everybody's time. You got to be very transparent with the judge. There's no reason to do that in family law to begin with. Did you have anything to add to that?
That's true.
Oh, the other thing I wanted to add to.
I mean, that was
the only other thing I would add to that is the judge made mention to her and the defense team being demonstrative when they didn't like the decisions that the judge is making. Don't make faces at the judge. Don't shake your head or nod or gesture to the judge in any kind of a way or speak over the other party or much less speak over the judge. That's the quickest way to piss off the judge. If they see you making faces, they might even comment it in open court. I just had a judge last week. Somebody like chuckled in the audience that wasn't even involved in the case. And then the judge stopped everything to yell at that person and knock it off. And then the bailiff went and had and talked to them and, whatever. But yeah, don't do that to the judge. I mean, they're sitting there listening to people bicker all day long. They don't need to have to deal with your, they understand that you disagree. You don't have to show them with your mannerisms.
Exactly.
And they're going to give you an opportunity to respond to whatever it is you're disagreeing with. And if they rule against you after you've told your case, then, hey, if you don't like the decision, there's mechanisms with how to challenge it. Don't do it on the bench because that judge is going to continue to be your judge, probably for the duration of your case. So that's all I really have to comment on the Parkland stuff. Girls, did you have anything to add? It's okay if the answer is no. So, moving on. Like that. All right, so let's talk about 3044 presumptions. We've talked a little bit about this before in domestic violence and why they're so important and how they complicate cases. Sometimes you get unique situations like I've had in the past where a restraining order was granted against my clients, but the minor child in the case lives with the person whom the restraining order was against. How do we do that when there's a 3044 presumption? And it's important to understand that when a restraining order is granted, that is evidence that domestic violence has happened in the relationship. It automatically triggers this presumption. It's rebuttable. You could overcome it, but there's only a few ways you could overcome it. And I'll point out that you don't need a restraining order for 3044 to hold. Like if you could present evidence outside of the confines of a domestic violence restraining order that something has occurred, then it can apply. But most of the times it comes up in these DV situations. And so what do you know, or what do you, what's your experience with the 3044 presumption, Iliana?
Of course, it comes into play in a lot of the custody and visitation cases, especially if there's a restraining order in family court or in criminal court. And I've been in both sides where my client is the one that is restrained or the other party is the one being restrained. And it is a very difficult situation, especially for the one that needs to overcome it, because it's not something that usually happens fast or as fast as the clients want. But it's there to protect children at the end of the day. So,
Yeah, I think one of the ways that I've seen Riverside County handle the presumption is, in addition to 3044. So understand that there is a presumption in family law where, when we're making custody orders, that it's in the best interest of the children to have continuous visits with both parents. That's the first presumption. But you don't get to use that presumption if 3044 applies. Now we have to get over 3044.
Exactly.
3044 prevents, it basically what it states is there's a presumption against giving any custody to somebody that's committed acts of domestic violence against the mother of the child or the father of the child, whatever, the parent. And so what you'll
Within the
find
last
oftentimes,
5 years, I believe.
within the next, yes, going back 5 years, anything over 5 years is not within that realm. But yeah, so you'll have, after a domestic violence restraining order, one parent will get sole legal and physical custody, and the other party will have visitation rights, or they might not have any visitation at all, or they may have supervised visitation, but they won't have any legal or physical custody because of 3044. You could overcome that presumption. There's only 7 different ways you could do it, and I listed them out. I didn't list them out. They're actually listed out in the statute itself. But one of the ways is you got proof that you've taken a parenting course, an anger management course. You complied with the terms of, something the court ordered you to do, or perhaps the criminal courts have ordered you to do. There hasn't been any further incidents. You've complied with the order. There's only very specific ways. If you don't do any of those things and all you have is, oh, well, I think it's best if the child wants to if the child is able to see me, that's not going to fly with the judge. You have to do these other things now to compensate for it. One unique situation that may occur is if the child lives with the person against whom the restraining order was granted. So let's just say mom took out a restraining order against dad, and the children live with dad, and they're the primary custodial parent based on recent orders. And mom doesn't have a significant amount of custody time. If a restraining order is granted against father for whatever reason, 3044 presumption will apply. But the judge also has wide discretion to make orders that are going to be best for the children. They just have to do it in the confines of the 3044 presumption. So what does that look like if we can't award dad custody? In Riverside, one of the things that I've seen them do is take into account the reality of the child's living situation. So where they might not give the other parent custody, what I'll say is this. They might not give in the hypothetical I just listed, they might not give the dad any custody, but they won't make any orders that the child is to go to the other parent. But they will grant sole legal and physical custody to the other parents because they have to, because of 3044. If there hasn't been any evidence presented to overcome that presumption, it's mandatory that the judge has to take that into account, and they cannot give any custody to the other parent. So I don't know, have you ever encountered that scenario? And if you have, how has the judge handled it in your case?
Yes, I have encountered it a couple of times where what it's in paper in terms of the orders is not necessarily what it's happening. So to give you, let me see, from the cases that I've done, there's one of them that I remember that they gave sole legal and physical to mother, but then the visitation to father was actually 50%. So it was more of a share legal than a sole legal physical. And I had one case where it was similar to the one that you were mentioning, where they give sole legal to one parent, but then they just say physical to the other, which makes absolutely no sense. But hey, like I even remember having a opposing counsel, like we were talking about this, because it just didn't make sense. Like the order was saying one thing, but what was really happening was the other. But the judge couldn't do anything about it. At the end of the day, the child didn't want to go with the other parent. The child wanted to stay. He was older, with the restraint party. And what was the judge to do? I mean, other than make the orders.
Yeah. And I mean, there's competing laws when it comes to 3044. And that's why the judges treat it the way that they do. They basically treat it as a hands-off.
Yeah.
I mean, on the one hand, you have Family Code 3021 and the Hugo case from 2016 that says that the court may make any order for the custody of the child that seems necessary or proper. But in the same case, namely the Hugo case, at the same time, they say that the 3044 presumption is mandatory and a court has no discretion in whether or not to apply it. And so that's why you have these strange orders where it's like, okay, well, you're going to go live with dad. We're not going to order anything. So legal and physical to mom.
Yes.
But I'm not going to order an exchange of the child. And the reason why is because the law is contradictory. And on the one hand, it gives judges the discretion to make whatever order is necessary for the child, but mandatory. I can't give you any custody because of this presumption. And you have to show me one of these seven. Well, these 7 things have to give me permission to get rid of the presumption. Also inherent in the presumption is if a judge does order anything greater than supervised visitation, it's mandatory for the judge to state how they're able to order that. On what basis did they overcome 3044 presumption? That's why when you hear the judge in the courtrooms, they'll make the orders. I'm going to order every other weekend a dad or 50-50 or whatever, this 223. I'm making a finding that the 3044 presumption has been overcome by the submission of evidence of dad taking all these classes. Or they might make a statement based on the actual living arrangements of the parties, which wouldn't be related to 3044. And that's the contradiction. And that's what throws everybody off.
Yes.
And it's why you and I will have these cases where the attorney's like, these orders don't make any sense. I don't get it. And because it doesn't make any sense. Because what you have is a case, namely the Hugo case from 2016, that is speaking out of both ends. It's saying that the judge could do whatever they want, but you have to apply 3044. And 3044 doesn't allow you to give custody to the restrained person. So how do you reconcile that? Well, then you're going to live with the restrained person, but so legal and physical of the other parent. Does it make sense? No. Is it logical? No. But is it the reality of the law right now in 2022? Yes. And it's been that way since at least 2016. So it's relatively new, but it's getting kind of old. And I think, this area of law is ripe for evolution. And I think there's going to be some cases coming out.
I think so too.
Pretty soon that changes the rules. But for right now, understand.
Yes.
I will tell people that the restraining order is going to create a 3044 presumption, and it means the other parent can't have custody. And then it's like, oh, so do I get my kids, or we're going to flip custody? And it's like, why don't we hold off on that? Case by case. Most of the time, the restrained person doesn't have majority custody. On the rare occasion that it does happen,
yes, that's true.
You will have sole legal and physical custody because the judge has to make it that way. But it doesn't necessarily mean the child is going to be ordered to live with you. It just depends on the situation. And then if you ask me what is my legal basis for saying that, I'll just point to the Hugo case. And I keep making reference to the Hugo case. The Hugo case is Celia S. versus Hugo H. from 2016, 3 Cal App 5th, 655. it's the case that kind of has written the protocol for this 3044 presumption. So in the event that you have a restraining order against the other party and you're hoping to use that to gain custody of your children, just keep in mind that the judge has wide discretion to do whatever they want to do in the confines of the 3044 presumption. And within the confines of the 3044 presumption, you will likely be awarded custody, but it doesn't mean that you're going to get 100% zero visitation of dad if the child's already living over there. Because at least in Riverside County, they will take into account the reality of the child's living situation. Girls, what do you think about all of that? Well, I mean, revenge is a tricky thing when it comes to the restraining orders. I mean, oftentimes I think people find out that if you file a restraining order against the person and it's granted, lots of things could happen for custody because they know that you have a lot of frivolous complaints. I've actually seen a situation where because of 3044, mom was awarded sole custody, even though there was allegations of child abuse in the case because of 3044 and because of the rigidity of the presumption and how it applies. So to answer that question, it's a tricky one. The academic answer is, it means you're going to get sole custody. The academic answer is, it doesn't necessarily mean the child's going to be with you 100% of the time. No visitation of dad. And the lawyerly answer is, I need to learn more about your case. And we need to see about what's going on with the children, what's going on with the custody arrangements, what's going on currently with the visitation, what's the nature of the restraining order. We just need to get to the bottom of the facts. One of the things I like about family law is very rarely do you have these clear-cut situations. A lot of things is very facts dependent. And so it's hard to advise, somebody on this without knowing everything. But for the question about whether or not you're going to get custody of your children just because of 3044, the answer is yes and no. And I would advise either you to give myself a call or give Iliana a call to discuss further, because there's some things that we need to talk about, probably not in the context of this show.
Yes.
So with that said, I think we should talk about palimony. So, I don't know. I'm going to play this clip to kind of set the context. This clip was sent to me by one of the people who listens to our show. Not on YouTube. I find that most people listen to us on the podcast because our YouTube video quality sucks. So I've stopped doing the live show. But I was sent this video and they wanted to get my opinion of it on it, and I'm going to give it.
Probably most of the people did not see. Obviously, when I first got with this person, they were already established. They already had the mentality to be where they were going. They already had been making six figures on the low end. They already had owned a couple spaces. They own like clubs and stuff in the city. So they already had these things. When I got with them, they had, entrepreneurs go through ups and downs. So they had went through their they're down in that moment when I first met the person. The first 2 years of my relationship with this person, I didn't get nothing. I got lunch and dinner and little shopping things here and there, like H&M, nothing too crazy. But I was helping this person do the back end for no money. I wasn't getting paid, do the back end of their business. I got them an investment in which they didn't even have to pay back. It was more of a barter. So they got the cash for, then the person then just wanted to use the space. So they didn't even really have to put in work to pay back in cash, So I did all that. We were very close friends. And then our relationship came to like, well, we stayed friends. We talked every single day, and it dwindled down into like we weren't fucking no more. We weren't doing like those type of things anymore. And we were fine with it. And then eventually I started like talking to people, and he would talk to people, and we would tell each other like we were friends, you know? So when he got me the apartment and the car, we were already friends, and we were already in a space where things weren't that for about 5 months, probably. It was about like 5 months when he got me that.
Okay.
Yeah.
So it sounds crazy. This sounds wild to me. Because what I'm hearing is a relationship where you and your, let's give him a name. Call him Carl. Would that be all right?
Yeah, that's cool.
All right. So you and Carl are together. Carl wasn't broke. He had a job. He had businesses. He had things going on. He may have been in a more of a valley point in his business, but he obviously wasn't broke and he wasn't homeless.
Right.
Y'all start dating, and you brought your skill sets to the relationship, like kind of like everybody does. And you guys helped him. And would it be fair to say did he help you in any way in any parts of your professional career?
Yes, for sure. I mean, in regards to like my backstory, he was a positive, like one of the first positive people that I ever had in my life that kind of like pushed me forward, believed in me, like gave me like positive affirmation, that kind of vibe, and anything and everything that I want to do. Huh? I'm
listening. I think there's a slight delay, so I'm just waiting.
Thing that I wanted to do, like in regards to my career, a lot of my skits were like shaking ass, and I used to like work on Instagram, like maybe 2-3 years. He was like all for it, like whatever it was, like whatever makes you happy,
Okay.
So for sure.
So you guys helped each other in a relationship. You had connections and things like that. You did back office things, but where it seems to kind of go off the rails is the relationship. Now you're single, you have a child, right?
Yes.
Was it before this relationship or after? Or during?
Yes, my child is a little grown. He's like grown.
Okay. All right. So you guys had your relationship, your boyfriend and girlfriend, whatever we want to call it. It went through the normal cycle. And then towards the end, the things you had done to help him started help his business increase or improve, as far as what I'm hearing you say. But you guys were friends, but you were living together still, right? Or were you not living together?
No, never lived together. The topic of the show was, would you give your ex back a gift? So we never lived together. He had his own separate.
So how'd you get the upgrade? So as you guys were friends, and then he upgraded you to a loft and a Mercedes, right?
Well, the Benz came a little bit before the breakup, but the apartment and stuff. But he kept paying after, we're talking to different people, paying forward. So
I want to read something real quick because I thought I heard you say it, and this is kind of what I heard in one of the clips. It said something. I'm not going to just move out of my space because we broke up. I'm not just going to give back my Mercedes because it didn't work out. If he had wanted them back, would you have, if he had wanted the car back, would you have given it back to him?
No. So I'm glad that wasn't the case. That wasn't the case with my situation. But if he wanted it, no, I would not have given it back. I would have been like, you have to wait till the lease term is up. And when that is up, then, everything is over. But you gave this to me. Was the lease in his name? Yes.
And same thing goes for the loft. If he had wanted the loft back, would you have given it up?
No.
Is the loft in his name?
Yes.
How would you have stopped that?
I was not going to go anywhere, period. I don't know. You're going to have to figure it out. Obviously, this is the ugly side of me. And so I'm grateful that didn't happen between us. But
I'm just.
Yeah.
That's pretty much the gist of it. She goes on to say, it's a really long video. It goes on for like an hour like that. But basically she's saying she wants palimony. Oh, wow. She wants him to keep on paying her bills and paying for the car and paying for the lease on her apartment. They were never married. And she made reference to their relationship and she mentioned at some point in the video that she wanted palimony. And they were going to get into the legal discussion, but I could tell you legally what would happen in California. Palimony is not, it's not a thing. It's not something that's litigated in family court. The way that it pops up in California is in civil court. And what she's making reference to, it sounds like they had some kind of a business that they had built or she had some involvement in. And if she were to try to bring a claim for some kind of business understanding, she would have to prove a contract between him and her, but it wouldn't be in writing. So what she would probably say is that it was made, these were things that I did in contemplation that we were going to get married. And I wouldn't have done these things had that not been the case. And therefore, I want what's owed to me. And she'd have to find a way to prove what that would be worth. The way that I've seen it pop up is, for example, a couple buys a house together. One puts down a down payment and funds the mortgage, and they're thinking about getting married, and then they don't get married. And then she wants half the house like they were married. What she might do is like a quiet title action because she contributed certain things in contemplation of marriage as if they were going to get married. And she would not have done those things if they weren't going to get married. And she wants her money back. The problem with that is that any contract involving real estate has to be in writing. So what they're really relying on is this offshoot in law, this remedy in contract law, where one party justifiably relies on the promises of another and acts as if they are bound by a contract, even if they're not actually bound by a contract because of it's not enforceable, because not in writing. And they want to, and if the court didn't recognize a contract, and then this other party would be unjustifiably enriched. That's essentially the nature of the lawsuit, and that's a civil lawsuit, and you could recover damages under that scenario. But for the kind of stuff that she was talking about, where she's going to keep the car that's not in her name and the apartment that's not in her name, and she's just not going to leave. I mean, the sheriff is just going to take her out of there and get her stuff out, put it on the sidewalk, whatever she wants with it from there. I don't know. Nobody's ever actually asked me this question, and I was kind of flabbergasted when I saw this video the first time. Girls, what did you think about that? Have you ever had any of your friends make such a claim to either of you? Explain. You could keep it all anonymous. Like, don't call anybody's name out. Oh, Jesus. Yeah, I mean, I have a lot of opinions about that. There is an expiration date when it comes to that kind of thinking. And women like this young lady that I saw in that video, I mean, I don't know. I should probably keep my opinions to myself. All I'm going to say, go ahead, Iliana, before I say something wrong.
No, what I was going to say is that I actually had a case very similar to this. Before, when I was working for a firm, I got assigned a case where the parties were only married for 2 months, but they were in a relationship for about 2 years. And during those 2 years, she was basically working for his real estate firm. He was into flipping houses. So he promised her that she was going to get a share of the sale of those houses once they were flipped. And she pretty much took over the company. He had some other issues, so he wasn't really running the company. She was doing it all those 2 years. She wasn't getting paid at all. They get married, and then they are going through a divorce. And of course, she wants her share of the houses. She wants to get paid for the work that she did. She wants all the money also for all those years because they had a really expensive lifestyle because they had a lot of money. And I mean, unfortunately, in family court, even the judge told her, guys were married for 2 months. I can give you 1 month of alimony, and then the rest you have to go to civil court and put a wages claim, or it's not in family court. But I had a similar case like that. It was a little bit crazy.
I had a
have
case
to say,
like
and
that.
convincing the client.
Yeah, almost exactly. It was the same thing, flipping houses. And, they were working together for a number of years. They were together for like 10 years or something like that, but never got married. And she wanted to sue for breach of contract. And one of the claims that she was making was that all of these things were made in contemplation of marriage and she should be refunded.
Yes.
We never actually litigated. That case ended up settling. But she had a legitimate claim insofar as she could prove that even though the contract wasn't in writing, I would not have put myself out like this if I didn't think we were going to get married. And he led me to believe we were getting married, and we bought engagement rings and we set wedding dates, and he pulled the rug out from under me. I want my money back. She might, under the legal theory of unjust enrichment, be able to recover something. But we settled the case before we could find out. And, it's but the way that this lady is talking about it, you don't just get to demand palimony and monthly payments and continue to pay your bills. He has no obligation to you. If you're not going to marry the guy, or if he never proposed marriage to you and you're living in this arrangement, there's a whole category of men that will do that kind of thing. And they will pay women for their company, and they will buy you things, and they will do all this stuff. But there's an expiration date. If they're not going to get married to you, then that's all it's ever going to be. And when they pull the rug out from under you, all of the gifts that you were getting, you're not entitled to them any further. Those kinds of things, alimony is reserved for wives, husbands, marriage. And if you don't get married, ultimately, that's just kind of the nature of things. In the very limited scope that we laid out, where you're, entering into a business together, putting your own money out there and working towards something, that's different. But if it's you're getting these gifts and you just want it to continue, but you guys aren't together anymore and you weren't married, California doesn't play that. Also, common law marriage is not a thing.
Yes.
Where you've been married for married. You've been together for so many years, and it's just like we were married, and so I should get alimony. California doesn't do that. We don't recognize that here. So that's my take on palimony. Did you girls have anything to add? Jocelyn, what are you smiling about? I disagree.
That long.
In my opinion, I think that you guys get off easy by not having to go through a divorce. So if for whatever reason you were together for that long and you split, you should rest on the fact that you're not having to go and divide up all of your stuff and go through the whole divorce process, and just go on about your merry way.
It's me.
Yeah, that's the distinction. If you're just getting gifts and you want the gifts to continue, it's not going to happen. But if you have legitimate business, you might have a claim in civil court based on contract law, but it's not going to be entertained by family law, and it's not going to work like alimony. And that's just how it is. That's the law. Did you have anything to add, Iliana?
Yeah. Yes, actually, because it's a pet peeve of mine. Gifts. Is it really a gift if it is in the party that purchased it name? Like, for example, in that video, the car and the apartment are in his name. So is it really a gift? It's not. And I see all the time this post in Instagram where the one of the parties, my husband or my boyfriend got me this new car, but the car is in that party's name. That's not a gift. At the end of the day, legally, it's their item. You get to use it while you're together, I guess, but it's not really a gift. So you don't get to keep
drive
it.
the car doesn't mean it gets to be yours. They didn't put you on the title. They didn't buy it for you. They bought it for them. And if you're
Exactly.
not together anymore, his next girlfriend is going to drive it, maybe, if he doesn't get it. That's just
It happens a lot.
I mean, don't be fooled. I mean, if you're going to engage in those kinds, if you're going to accept those kinds of gifts from men, and you're not married, and you think that that's going to continue, and makes you feel a certain way, and you feel powerful, just understand, if it's not in your name, you don't own anything. What you're being given is a gift, and you should have no expectation that those gifts are going to continue unless he puts a ring on the finger. If that's what your ultimate goal is, get him to do that. And if it doesn't happen, and you're not trying to do that, or that's not in the cards, then you just have to be satisfied with the fact that you guys are going to have a clean split. He doesn't owe you anything. You don't owe him anything, and you guys should move about your married lives. But with that, we are 7 minutes over. We've been going for an hour 7. And this was episode 10. I think that we were able to pull it off. And it's really good to have you back, Iliana. I think the show doesn't really work well without you. And we've worked out our difficulties. One day we're going to get you here into the office, so we were not having to do this remotely. But with all of that, thank you, girls, for joining us for episode 10. We are no longer doing the live show anymore, and the reason why is just because you get lower quality feeds with the live. So from now on, our show is going to debut every 3:00 on Fridays. It's going to debut on the it's going to post on the YouTube channel, on whatever podcasting platform you listen to, whether it be Apple Podcasts, Podbean, Castbox, Stitcher, whatever you listen to, our podcast will be available there every Friday. And like clockwork, unless an act of God happens, such as my co-host gets stuck in a hurricane in Puerto Rico. Other than that, we will see you guys next week. And thank you all, and we'll see you. Have a wonderful weekend. Thank you all for listening to the entire podcast. We really do appreciate that. And as always, you can find us on YouTube on the Tilted Lawyer Podcast YouTube channel, or on your podcast carrier of choice. If you feel we've presented anything of value, please leave a 5-star rating, like, and subscribe. We always appreciate that kind of thing. And we do look forward to seeing you all again live every Thursday at 3 in the afternoon. We love you all. Take care. Bye-bye.